Good afternoon and welcome to the McGuire-Woods inaugural EdTech Webinar. My name is Farnos Thompson and I am the chair of our education industry team and a partner in the Labor and Employment Law Department in DC. We have a full program for you today and will offer a live demonstration of artificial intelligence in education. Our partners will discuss intellectual property and data privacy issues unique to artificial intelligence in education. We will go over the Federal Trade Commission's enforcement of the Children's Online Privacy Protection Act, as well as the Gramm-Leach-Bliley Act Safeguards Rule and its applicability to post-secondary institutions that receive federal student aid. Finally, we'll briefly cover online program managers as potential third-party servicers and the Department of Education's guidance on artificial intelligence, as well as its authority to regulate it. While I am part of the law firm McGuire-Woods, I would like to note that we have a separate entity, McGuire-Woods Consulting, that does everything from lobbying to business development to coalition building. And McGuire-Woods Consulting is in the process of creating a coalition of EdTech companies and organizations to protect and advance this industry. If you have any questions, we welcome them. There's a chat function, and please place your questions in the chat box, and we will address questions at the end of our webinar. You're also welcome to contact any of the partners who are part of this webinar directly with questions, and we will do our best to respond to them. My esteemed colleague and partner, Justin Lowry, who is in our intellectual property department in the Richmond office, will now present a demonstration of artificial intelligence in education.
Well, good afternoon, everyone. We thought we'd start with kind of a base demonstration of ChatGPT, which is obviously probably the most prevalent or most commonly known of the AIs that's out there for people to use, especially some examples of how administrators or teachers or students may be using it in the education space, just so we have kind of a baseline of how it may be used already in your schools or in your universities, or how you should be thinking about it. So I'm going to be starting with a base demonstration here. We've got ChatGPT's website open. This is freely available to anyone who establishes a research account with them. And at the bottom here, we have a prompt entry point where we can enter whatever we want ChatGPT to respond to. So for example, here I have generating a form letter to a parent of a student who was caught fighting in school. So you have a serious incident in your school and an administrator or principal needs to put together some sort of correspondence back to the parents. ChatGPT will take that in and then we'll start generating a response automatically for us. And you can see it recognizes kind of what a form letter is and what it's being asked about. It has my name, my title, position, all the things I would be inserting in that, and then a pretty basic yet comprehensive letter responding to what we asked about it in terms of a student being caught fighting in school, writing to inform you about an incident that occurred at a school recently involving your child and to discuss the actions taken by the school, an incident during school hours. We take this very seriously, investigating the matter, specify disciplinary actions taken. So again, a pretty comprehensive response that an administrator or a principal would be putting out to that sort of incident. Now, turning to kind of maybe how a teacher might be using ChatGPT. Let's say I'm a new teacher who's looking to teach math in high school and I'm looking for some ideas about how to get algebraic concepts out to my class. Let me ask it, what are some ideas for how to teach basic algebra? And we have it kind of with a preamble of teaching basic algebra can be made engaging and accessible for students with a variety of strategies, and then listing a long set of different strategies, real-life examples, visual aids and manipulatives, step-by-step approach, technology, group activities, problem-solving, mnemonics, analogies, and so on. A pretty, again, comprehensive or lengthy list of ideas on how to approach algebra. And let's say I've had some success with manipulatives in the past, so I want to ask it to maybe provide some more detail specifically on the use of hands-on manipulatives in algebra. And now it recognizes the conversation that we've had before. It knows that we're talking in the context of teaching algebra, and in particular, I'm asking about something it already mentioned. And now it will go into more detail on the specific thing I mentioned, providing examples of using hands-on manipulatives in algebra, tiles, scales, cups or containers, games, different models or blocks. Again, a pretty good starting point for a teacher that's looking to implement that sort of technique in their class. And so now let's move on. Let's imagine I'm a teacher who's coming back from a summer where students have just read Huckleberry Finn, and I'm trying to prepare my lesson plan for how we're going to be teaching or talking about Huckleberry Finn. So let's have it generate a lesson plan for teaching Huckleberry Finn. You can see it starts out by immediately recognizing when I said Huckleberry Finn, I of course meant Mark Twain's The Adventures of Huckleberry Finn, and it's providing a pretty standard looking lesson plan. Grade level, duration, objective, materials, and then a lesson plan running through discussions on day 1 of the novel and author, discussions on day 2 of character and themes, social commentary, creative projects and reflection, and then an assessment. Again, a pretty good starting point in terms of a full lesson plan. And I'll say, in preparation for today's presentation, I've asked it this question many times, and it always comes up with a slightly different answer, which is interesting. Is sometimes it has a lesson plan for weeks, sometimes it has one for an afternoon. So this is something that the teacher could go back and say, well, I only have a day to teach this. Can you give me a lesson plan for teaching it within a day? And it would be able to respond to that sort of adjustment or request. And next, a teacher that's finishing up a module and wants to provide a quick quiz to their students, generating a list of 10 questions, for example, to test knowledge on the American Revolution. And ChatGPT going into some of the major topics of the American Revolution. What event is often considered the catalyst of the American Revolution, leading to the formation of the Continental Congress? Name 3 key figures who played significant roles in the American Revolution. What were the Intolerable Acts? What was written by Thomas Jefferson? Things that, at least from my memory, match up pretty well with the American Revolution, or things that you might ask about in the context of the American Revolution. And as it notes here, you could specify, well, actually, I would like these in multiple choice format, or to be essay questions, or short answer, or whatever format you're looking at. And it would be able to adjust based on that. So moving from the teacher, now let's look at a student who's in that same history class and just finished with an assignment asking them, what are the causes of the American Civil War? You can go to ChatGPT and it will provide, a context, the American Civil War, 1861 to 1865, and then listing out what I think we would agree to be the major causes: slavery, states' rights, sectionalism, economic differences, political fractures, and so on. And I'll say once again, I've asked ChatGPT the same question, and I always get a slightly different listing of these topics. It normally always starts with slavery and states' rights as the major disputes, but kind of when it moves on from there, I've gotten different listings, or at least different discussions of this every time I ask it. But I think in terms of what everyone's likely thinking, let's move on from just asking it a research question to asking it what might be the ultimate assignment. Let's have ChatGPT write an essay on the causes of the American Civil War. And now it's taking what likely was listed up there above and turning it into straight essay format. Starting out with an introduction about the American Civil War, and then writing about the different topics we see here listed: slavery, states' rights, sectionalism, now all listed in essay format. And let's say I'm a student who recognizes maybe it's not a smart idea to immediately take something that ChatGPT wrote and plug it into an essay that I'm going to submit to my teacher. I'd like it to be modified a little bit. Let's ask ChatGPT to punch that essay up with more active language, because I always love active language. I know having imagery in there is going to help me in getting the grade I want. And now we've got what already is a much more interesting sounding essay, The Catalysts of the American Civil War, A Nation Divided. One of the most pivotal events in American history. It tore at the very fabric of the nation, claiming countless lives and deeply polarizing the people. So already I think this essay is going to do a lot better for me in terms of what I'm going to be submitting. So I think the combination of this will hopefully illustrate both the promise and the peril that something like this will have to pretty much any educational institution in terms of the students and the teachers and administrators. And now I'll talk a little bit more about the actual legal issues as well as what is going on behind the scenes with ChatGPT.
And so turning from that to kind of what ChatGPT and these other generative AIs are, and I'll clarify, we recorded the demo there in advance just to make sure ChatGPT would be available. They've been throttling access to the system quite a bit because of its popularity, and we wanted to make sure that did not happen live with all you good people on the line. But ChatGPT at its base is what's called a generative AI. It's an AI program to generate new content. And in particular, it's a model that's trained on large data sets to identify patterns and structures within that data and thereby be able to respond in some way and generate new content for you. These types of models are attached to any type of media that you can think of. There are a number of different text-based models such as ChatGPT, Google's Bard, as well as other ones that are more focused on different types of writing text, either copy editing or revising drafts or different things. There are image generators such as Dolly, which is another one provided by OpenAI, who's the maker of ChatGPT, Bing image generator, and a number of others. There are tools for music generation, audio editing, and voice generation, video editing, content generation, potentially taking scripts and turning it directly into video. All of this is, again, working from the same idea of taking a large set of data and then programming something or training something to perform some specific task for you. And it does this by using a huge corpus of training data. The training data is an extremely large data set that is used to teach these types of AI models to understand and respond to the prompts or the tasks that you are giving it. So in the case of ChatGPT, we don't know fully what their training data set is because they keep it private, but we know at least it incorporates articles, books, conversations, forum posts, public websites, all sorts of public information out there on the internet that the model will take in and then use that to understand what words are and how words relate to one another, how people speak to one another, how people relay questions back and forth, how paragraphs are formed, and what's the difference between a paragraph essay and a lesson plan or a form letter. All of that is taken from understanding millions, if not billions, of sets of data, and then using that to be able to understand how we speak to one another. And these models, upon taking in this training data and building a network of information, will then have the ability to respond to some sort of input or prompts or requests that you're providing to it and give back some sort of output to you. So in the case of ChatGPT, which we looked at, you have an input or a prompt, such as write an essay on the causes of the American Civil War, and then we're getting an output or response back in terms of here are the causes, here's your essay that you asked for. And importantly, the way ChatGPT and most of these models work are they're iterative. They build upon themselves through repeated interactions. So they learn from the interactions that they're having to improve themselves. ChatGPT has released a number of different versions over the course of the last months and years that have continually improved the system. And as you continue to interact with it, it will continue to build its knowledge base and improve the way it interacts. And your basic image generators work in a similar fashion. For example, I use Dolly, which is, again, another solution provided by OpenAI, to ask it to provide an impressionist painting of a lawyer giving a CLE presentation. And I got back impressionist-looking pictures of lawyerly-looking individuals sitting at a podium and giving some sort of presentation. I don't know how it's particularly a CLE presentation. It probably did not understand what I was asking there, but the rest of it matches up pretty well with what I was asking. So with that baseline, sorry, trying to pull up my slide here. What are some of the benefits of using AI technology? And I think likely you saw a lot of them, or at least the promise of a lot of them in that demonstration, but you've got speed and efficiency, the ability to generate quick drafts, templates, or media in multiple different formats. You've got reduced cost and time for routine tasks. So if you have marketing copy or form letters or something that you're doing very often, you may be able to have this generate quick copy or quick initial drafts for you, something that you may ordinarily ask an assistant or ask an associate to work on. You may be able to just ask an AI model to generate something for you. These general purpose models, such as ChatGPT, are also very flexible. You can interact with them in a natural language form, which is very important for anyone who's had to sit through multiple different trainings on using different types of software or had to wrestle with Word or PowerPoint to have it do what you want it to do. If you can interact with a piece of software to generate something in a natural language format, the same way you would interact again with an assistant or with an associate, you can potentially have it generate something for you much easier. These systems are also very adaptable to different problems or needs. You can ask ChatGPT or other general purpose models pretty much anything you would want, and it does a pretty good job about providing an example back to you. And I'll say, I think a lot of these are going to be refined down and then adapted for different spaces, such as the education space. You can think of a version of something like ChatGPT where you can ask it specifically for customized lesson plans or to generate problem sets for you or to generate teaching materials for you. They're adapted for the education space, but at least as it stands now, these general purpose models do a pretty good job about getting you there. And the last major potential benefit is creativity. You can use it to generate new ideas or designs. They often can provide unexpected responses that you can then refine and work on further. All of this can be helpful in terms of the creative process and you developing materials. But coming along with that are the obvious dangers. And I think in the education space, the thing that's top of mind for everyone and likely is top of your minds after the demonstration is plagiarism and cheating. And I think if anything, my demonstration underrates the concerns with respect to plagiarism and cheating using generative AI. There was a study done in the last couple of months by a group at MIT that took the MIT mathematics and engineering curriculum or a number of problem sets within that curriculum and using careful ways that they interacted with ChatGPT and using the most advanced version of that model, they were able to achieve a perfect solve rate on that test set of questions. The NEA also published an article on their website citing a survey from teachers saying that 1 in 4 teachers had reported catching students using ChatGPT to cheat. And I think this is something I talk about essentially with every client and I try to get across is that undoubtedly your employees or your students are already out ahead of you on this technology. They are already experimenting with it, if not using it. And so this is something you need to be dealing with and aware of in terms of putting together policies, in terms of providing guidance both to students and to administrators or to your employees or professors or teachers. You need to start thinking about how to incorporate or how to ban this material if you don't want it to be used and how to be going about those things because very much every organization I've interacted with this, there are people that are already using this, if not, as I said, incorporating it into their workflows. And unfortunately, right now in the education space, there are no great solutions in terms of a post hoc way to look at material that has been generated and say, was this written by an AI or was this written by a human? There are a number of tools that are trying to be developed that would accomplish that sort of thing. So a professor could look at an essay and go, was this written by an AI or was this actually written by my student? But none of those tools that are out there right now are all that great. They have high rates of false positives in terms of identifying material that it thinks is generated by an AI, but is in fact not. And they fail to detect a lot of AI generated material. For example, I took the essay that I had ChatGPT write on the causes of the Civil War, my punched up essay. I provided it to a number of the different AI detection tools that are out there available to the public. none of them caught that it was written by ChatGPT. So I think it's a large problem, and it's something that you have to be thinking about in terms of your policies, in terms of the ways you're going about testing and talking again to your students and your teachers and administrators. OpenAI has also put out their own article on educator considerations for ChatGPT, which is, I think, a helpful thing to look at. It will talk about a lot of these same issues. It's obviously slanted in the favor of using AI, given their perspective. But it does mention plagiarism and some of these other concerns, and starts talking at least about things they're hoping to do that they haven't done yet to try to resolve some of these issues. And beyond kind of this elephant in the room for the education space in terms of plagiarism, there are just kind of the general legal issues that are going on around the use of AI technology. And these are things I cover with pretty much any client I'm working with that's thinking about AI or that's trying to incorporate AI in some way or set policies around AI. The first major one is intellectual property. There are currently ongoing lawsuits against generative AI companies based on the training data that they use to build their models. So there are class action lawsuits against OpenAI for ChatGPT. There are lawsuits against image generators. And a lot of it is based on the fact that the training data incorporates a ton of public material, including copyrighted material. And it's an open question as to whether the use of copyrighted material to build an AI model is a copyright violation, making these essentially huge copyright violation machines, or whether it is permissible fair use. It's something that's being litigated. It's something that was just debated on Capitol Hill a couple of weeks ago. So it's very much an open question, and that leads to uncertain status in the output in terms of how you can use it for intellectual property purposes, such that I generally advise clients to be very careful about how you're using this, and especially be cautious about trying to implement this in terms of anything you would consider mission critical or public-facing intellectual property. And my colleague who will be speaking next, Janet Payton, will be talking in more detail about some of these intellectual property issues. There are also big privacy and confidentiality issues when you're interacting with ChatGPT or a number of these different public models. You have no expectation of confidentiality in how you're providing input and the output you're getting out. Therefore, you have the potential to violate your student privacy policy or any other internal policies in terms of the data that you would be providing to it. And then the last thing which I try to get across to everyone I speak to on this is that these are not perfect models. They look very impressive when you're interacting with them, just in the demonstration. It looks great to be able to provide that sort of input and get a very appropriate and comprehensive looking answer. But the output of these AIs is necessarily biased based on the data it was trained on. And if you're trained on everything that's out there in the public internet, there are going to be flaws in that. There are going to be potential biases that are going to creep in that may go against your organization's policies, your DE&I policies, especially if you're thinking about using this for evaluative purposes, for either evaluating students or teachers or material. So you need to be very careful about how you're incorporating this and make sure you're checking any outputs that it corresponds with your other policies. And then likewise, the output of these models can simply be false. The AI can what's called hallucinate, generate things that it thinks are entirely correct, but are actually false. The classic example, which I think a lot of you probably heard about, is the New York lawyer that tried to use ChatGPT to generate a legal brief that they filed with a court. Brief looked great. It had citations to the Second Circuit and some quotes supporting all of the legal points they wanted to make. But once the opposing side got a hold of that brief and looked at it, they realized that all of the cases were made up. ChatGPT knew enough to be dangerous. It knew enough to understand how a legal citation is formed and what sorts of support that the lawyer was looking for, but it didn't know the difference between a false case and a real case. So again, you need to be careful about how you're using these systems. You still need to have humans in the process looking at the outputs and making sure that they're correct and sane. So make sure that you're keeping in mind the limitations of these systems whenever you're considering implementing them. And with that, I'll turn things over to my colleague, Janet Payton, who's also in the Intellectual Property and Transactions group here at McGuire-Woods. Janet does a lot of work in data privacy and other intellectual property issues, including with educational institutions, and she'll be speaking in some more detail about some of these issues related to AI.
Thanks so much, Justin. If you're not worried yet, you're a very calm person. So I am going to talk just a little bit more about copyright specifically because of all of the types of intellectual property, these issues seem to me to resonate most in the area of copyright. Obviously, patent is going to be relevant to some AI questions, and trade secret certainly is. But copyright is sort of fundamental to it. So I thought I would just do a very, very brief review of what is copyright. For those of you who maybe get it confused with trademark sometimes, copyright is the right of an author. The copyright is the right of someone who creates something original and fixes it in a tangible medium. So not just the written word, although certainly text is a key, thing that copyright arises in, but also things like photographs and artwork, graphic design, plays, music, all those things that are original works of authorship are protected by copyright. And when you generate original work like that, the copyright vests in the author automatically at law. It does need to be registered with the Copyright Office before you could bring a federal lawsuit against a third party for infringement. But that doesn't mean you don't have it. It is a legal right that you have as soon as you create something original. So the other really important rule to remember about copyright as we're going forward is, if copyright vests in the author, who is the author? I mean, we typically understand the author to be the person who created the work. There are some circumstances, though, where the Copyright Act will assign authorship to the employer. So if you're an employee and the original work of authorship that you create is created within the scope of your employment, then the author, the owner, think of it that way, of the copyrights in that work is the employer. So then what happens when it's ChatGPT that created the work? It seems like a big question. And as Justin just said, there is all kinds of litigation about this right now. But it's interesting that the analysis, the scholarly analysis on this so far has been that there is not copyright in AI generated works. And this doesn't mean that it didn't start with things that are protected by copyright. That's a totally separate issue. And a lot of the litigation is actually related to that. You're pulling in my copyrighted work that you're not allowed to copy without my permission, and you're using it to teach this thing, to write essays, and so on. So it's interesting because the primary case that keeps getting cited in the area of whether or not AI generated materials are protected by copyright is the monkey selfie case. Has nothing to do with AI at all. But there was a case started probably almost 10 years ago now, where a wildlife photographer set up some cameras in Indonesia. He befriended this group of wild macaques, and he was trying to get some very close-up pictures of them, but the monkeys wouldn't allow him to get very close. And so he realized that they were very interested in his camera equipment. So he set up the equipment hoping to get them to take selfies. And they did. And I really encourage you to Google monkey selfies because they're absolutely adorable. But given the huge amount of copyright litigation that has happened over them and the fact that there's a settlement, I was like, I'm just not going to copy these and put them in my presentation. But what happened with this is that the wildlife photographer got these wonderful selfies, published them, and then Wikipedia picked them up and put them into their public domain database of, free photographs that can be used. And the photographer took the position, they're mine, because I did everything to author them except push the button. I set up the equipment belonged to me. I put myself in the situation to be there with the monkeys, all those things. Anyway, the author and Wikipedia ended up settling out of court, but PETA, then the People for the Ethical Treatment of Animals, sued on behalf of the monkey as a next friend because the monkey could not sue on its own, to argue that the monkey owned the copyright. And the district court dismissed the case, and PETA appealed to the Ninth Circuit, which is just fascinating to me. If you're a copyright geek, this is just so interesting. So the Ninth Circuit upheld the dismissal. And the key language that brings us back to the question about AI was that the Ninth Circuit upheld the finding that non-humans, so monkeys are non-humans, but so is ChatGPT, do not have standing under the Copyright Act, and so cannot be a copyright owner. And that seems to translate to probably nobody owns copyright in what AI generates. But as Justin said, it's still up in the air. So then there is the opposite question. What about the materials on which ChatGPT's output is based? There is no guarantee that those materials are free for use. In fact, in many cases, it's almost certainly the case that there is someone out there with a copyright and they just don't understand that that material has been absorbed or put into ChatGPT by individuals who are not the owner in the first place and didn't have the right to do that, but they did. So it's interesting to read OpenAI, the owner of ChatGPT, OpenAI's terms. Their terms and conditions of use purport to assign all rights in the output that you generate when you put a question in to you. It purports to do that, but it doesn't guarantee that it has anything to assign to you. And in fact, just by the nature of AI, it's very likely that they don't own it, and that means you don't own it. So in the context of schools, there are situations where the school is going to want to be the owner of copyright, where you're generating curriculum, for example, and let's say you hire contractors, or even it's very typical to hire your own faculty, but sort of as a special side contract, generate a course for us. And the content of that course is protected by copyright. But if the course content was generated using AI, then it may in fact be that the person who developed it, the professor that's on the special contract, or some third-party vendor, if they used AI, it very well may be that they don't have copyright to transfer to you, to assign to you. Because as we said in the beginning, the author is the owner of the copyright, except in the employment context. And then if you're not an employee, if you're a contractor, the only way that copyright is transferred from you as the author to the person who hired you or the entity that hired you is by assignment. And so you would normally have a work for hire provision in your contract with the professor or with whoever to say, you agree, we will own the copyright here. But what if it was generated by AI? Since this is all really up in the air, the question that is really begged here is, do you put into those contracts a prohibition on the use of AI? And I really suggest that you consider that, because if you want to be sure you're the owner, if you want to be able to exclude others from copying and redistributing that material, which is often the case with curriculum, then you want to be sure it doesn't have material in it that's going to throw copyright into question. So something to think about with respect to contracts with vendors. Now, is it possible to use ChatGPT and to put content into it to get, one thing that is becoming a fairly typical use of ChatGPT is take a paragraph that was original writing and say, make this better. As Justin did, but he did it with the original was already ChatGPT, but you could take your own essay and put it in there and say, make this sound better. And it will produce something back that is a derivative of your work. If you switch off in the ChatGPT settings, the training, then it is possible to tell it, you don't get to pull my essay into your, huge data batch. So that is an option that they offer. I would caution though, and as you can see on the slides, I am sort of questioning the track record of major data platforms because in the social media context, they really have struggled to honor their own settings, particularly in the privacy context, which we're going to come to a little bit later. But the fact that ChatGPT offers this doesn't necessarily mean that it's infallible. So I would just be very, very cautious. about the use of it in the context of anything that you want to own the copyright in. So what is starting to become part of the conversation in the academic world is AI really like the calculator? You know, is it something where for years in the sort of olden days, you were not allowed to use a calculator in certain math classes. You had to just do the math yourself, show your work, and you couldn't use it. And then over time, it became more acceptable to use a calculator. And in fact, the value of the calculator for accuracy pulled us to the point where there are many math classes now where students are required to have a calculator. In fact, a very advanced one. But like the calculator, the message really is you need to think about AI and decide if it's permissible or not. Just like you need to tell your students whether or not they can use a calculator, it's important to tell them and your faculty and everybody else, your contractors, whether or not in the context of whatever it is you're expecting them to do, they are allowed to use AI or not. Because there are some situations where it's probably fine. There are situations where you're not looking at the output for creativity or something, that there's some other purpose of it. And if that's the case, then you might permit the use of AI. So again, in the student context, if you have AI banned for creative writing classes, that seems like it would make sense. But there may be some kinds of data analysis classes where it's useful to learn how to use it. So I strongly suggest that you add a thoughtful, comment about the use of AI in all of your university policies that have anything to do with generating content. It ought to be addressed in your IP policy. It ought to be addressed in your employee handbook, in your student handbook, and absolutely in your application process. If you want to tell students they may not use ChatGPT and it will be considered cheating or the application will be thrown out for writing those essays, it's something that you probably ought to put in writing. So let's quickly move on to data privacy and AI. So the issue here is if you're going to put data sets into AI that have personal information in them, it is very likely, if you haven't thought it through and planned for it, that you're going to violate the terms under which it was collected. So data is typically collected at schools through the application process, through the enrollment contract, through the grading process, and various other forms that are filled out by students. And of course, in the employment context, it's, when people fill out their W-9 or whatever other forms they're completing about themselves in order to, participate in employee benefits or whatever. So if you want to use AI to do that kind of data analysis, you need to be very aware of the kinds of data that you put into it. If it was collected under a privacy policy, it's going to be, a problem in terms of what did the privacy policy say you were going to do with it versus what did the, person expect was going to happen with their personal information. So OpenAI's terms of use, again, are sort of instructive here because they say, if you use their services to process personal data, you must provide adequate privacy notices and obtain necessary consents for the processing of that data. I strongly suspect that that is not what's in your privacy policy. We might put your personal information into AI, and you're representing to ChatGPT, for example, that you are processing that data in accordance with applicable law. So let's move on to this de-identified question because it's the next natural question. Can you de-identify data and use it in ChatGPT? Or do you need consent even to do that? All of this is so new that it's very much still up in the air, and it's very much state by state, country by country, topic by topic. So if you look at the Virginia Consumer Data Privacy Statute, de-identified data means data that cannot reasonably be linked to an identified or identifiable natural person or a device that's linked to a person, like the IP address of your cell phone or your computer. So you don't need consent if the data truly cannot be reasonably linked to a person. In Europe, under GDPR, anonymous information, and the definition is below, anonymous information is the type of data to which GDPR doesn't apply. And if you can meet this standard, then you're okay in terms of not needing any kind of consent and not worrying about violating privacy policies. But just as an example, under HIPAA has a very specific list, and it's on the screen now, of the kinds of things that if they are present in the data, it is subject to HIPAA if it's already PHI. So if something starts in a medical facility or a doctor's office or anybody that's subject to HIPAA, universities have hospitals and clinics, any data from those kinds of facilities, if it has these identifiers in it, then it is not something that you ought to ever put into AI for any purpose, because you're going to violate HIPAA. So there's so much here. Obviously, we could talk about it for each of these things for hours and hours. But I'm going to turn it over to my partner, Reed Smith, to talk about the FTC and COPPA in this context. Reed, do you have your mic on? I think Reed is having an audio issue, but he's trying to resolve it. Bear with us.
Do y'all want me to jump in and then we can go back to Reed's section?
Ashley?
Yes, technical help is on the way for Reed, so please go ahead. Thank you.
Okay, great. I am just skipping through his slides here. All right. Let me make sure I'm all set up. Okay. So I am Ashley Matthews. I'm a partner in our Charlottesville, Virginia office. I practice in the area of data privacy and security, and I have a consumer financial services regulatory practice as well. I always like to start these types of presentations by noting that I'm a lawyer and I don't have any special information technology training. I'm not a professional in that area. So please do not ask me if the CMS that programs the API is sufficient to meet the BICSS interface requirements for land security, because I will not know the answer. Okay, so what is Gramm-Leach-Bliley? The Gramm-Leach-Bliley Act requires financial institutions to explain their information sharing practices to their customers and to safeguard sensitive data. So that is a two-pronged test where there's a privacy side and a security side. What we're talking about today is the security side. This law was passed in November 1999. Who must comply with Gramm-Leach-Bliley? Gramm-Leach-Bliley applies to financial institutions. I like to play a script out with my clients where I say Gramm-Leach-Bliley applies to financial institutions. And then they say, but we're not a bank. And then I have to explain that Gramm-Leach-Bliley has a special definition of financial institution that is incredibly expansive. And it applies to any group of companies that are significantly engaged in offering financial products or services. That includes things like loans, financial or investment advice, or insurance. It applies to payday lenders, check cashers, wire transfers, banks, retailers that offer financial services. It's just an incredibly expansive group of companies. Colleges and universities that administer student financial aid associated with Title IV programs must comply with the GLBA safeguards rule. So why are we talking about Gramm-Leach-Bliley today? This law is not new. It came into effect in 1999, and it's also not new that colleges and universities are required to comply with the safeguards rule if they offer financial services. But the safeguards rule underwent a major change that went into effect last month on June 9th. So Gramm-Leach-Bliley and FERPA do coexist. FERPA is considered to cover the privacy portion of Gramm-Leach-Bliley, but the safeguards rule is basically the security requirement that applies to financial institutions or to education institutions that offer financial services. The old safeguards rule that was in effect prior to June 9th was incredibly vague and weak, and it just required companies to have appropriate safeguards. It had no specificity, and there was really no enforcement to speak of. The new safeguards rule is specific. It leaves very little to interpretation. First and foremost, it requires financial institutions to develop, implement, and maintain an information security program with administrative, technical, and physical safeguards. We reference that as a WISP, a written information security program, and that is something that is required to be appropriate to the size and complexity of the business, the nature and scope of the activities, and the sensitivity of the information at issue. So we often say all information is not created equal. If you have an inventory of the number of tissues you have on campus, that's obviously not protected information as compared to information that's personally identifiable, things having to do with people's financial status, that sort of a thing. The requirement to have a WISP is actually not a new one. The previous safeguards rule also had the requirement, but now the WISP is really important because it also plays into the elements that we're about to discuss. So the new safeguards rule breaks its requirements into 9 elements. And I do apologize, we are going to fly through these today because we only have a few minutes to talk about them. But of course, we're here to answer questions going forward. So the elements, the first element is that you have a qualified individual. This is a person who is responsible for overseeing and implementing and enforcing your information security program. Note that the QI can be a third party. It's explicitly permitted in the safeguards rule, but if you do use a third party for that, that would be often some sort of a third party information services or IT professional that you engage to serve in this role. You're required by the safeguards rule to exercise quite a bit of oversight. You have to that party has to retain responsibility for compliance with this part, but you also, as the covered entity, also have to maintain responsibility. And you have to designate a senior management of your staff to oversee the QI, the qualified individual. Element 2 is a risk assessment. You are required to complete a risk assessment, and once you have that risk assessment, your written information security program that we talked about before has to be based on that risk assessment. So obviously with the risk assessment, you would go through your company or your education institution, and you would identify the various risks, trying to keep an eye on internal and external risks to the security, confidentiality, and integrity of your data. And once you have that, you are to modify your WISP to acknowledge those risks. And so just as your risk assessment should be periodically updated, which is a requirement that's set forth in the safeguards rule, your WISP is also required to be periodically updated. Element 3 is called safeguards. Element 3 is kind of a trick because within Element 3, you have about 10 more safeguards that you're required to implement. Element 3 includes requirements that you implement access controls, both technical and physical. You're required to identify and manage data, personnel, devices, systems, and facilities that are within your institution. You're required to encrypt information in transit and at rest. You have to implement MFA, multi-factor authentication, for your institution. You're required to adopt secure development practices for in-house developed apps. I think that's a big one for a lot of financial or education institutions that develop their own applications. You must develop, implement, and maintain procedures for the secure disposal of information. And you're required to do that 2 years after the last date that you're required to have the information, or that you need the information. So we've actually been counseling education institutions on this particular requirement. We know that there's data that you all are required to keep much longer than 2 years, and that's a place where it's appropriate to look at what data you have and determine how long you should be keeping some of your data, and really go through an information governance process there. You're also required to monitor and log the activity of authorized users and detect unauthorized access or use. And I will just note, I've only read some of the requirements there. Within Element 3, there are quite a few. Element 4 is testing. That requires monitoring, penetration testing, and vulnerability assessments. Obviously, some of these things you might do every 6 months or a year, like a penetration testing, monitoring, and things like that are things that should be ongoing. So you should have your safeguards running on appropriate schedules. Element 5 is policies and procedures. Within that element, if you actually read the language, I think it might actually be better called training. There's quite a few training requirements in there. You're required to provide your personnel with security awareness training that is updated as necessary. You have to utilize qualified personnel employed by you or your service provider. And again, as we discussed before, your service providers have to be appropriately managed. You have to provide your information security personnel with security updates, and you have to verify that they're taking steps to maintain current knowledge of changing information security threats. A lot of what we see within the safeguards rule is really meant to target the idea that the threats and your own environment are constantly changing and evolving, and it's appropriate to remain nimble with your programs. Element 6 relates to service providers. We talk a lot with clients about service providers. We find that, I would say, Janet could speak to this as well as a lot of my colleagues, but more than half, I would say, of the data breaches that we handle at McGuire-Woods are caused by vendors or third parties, and not actually by the party that is having to claim the data breach. So it is of the utmost importance that when you're selecting providers, you're selecting those who have safeguards in place and who are going to maintain those safeguards. If their safeguards are good today, are they still going to be good in a year? So we want to see them continuing to maintain appropriate safeguards. And we want to continue assessing those service providers, not just with regard to their safeguards that are in place, but the information that we're providing to them. Does that ever change? Does their business change? Does their ownership change? All of that's really important for managing your service providers and vendors. Element 7 is that we evaluate and adjust. And as I mentioned before, it's really important to stay nimble when you're talking about information security. So we want to always continue evaluating and adjusting. We want to be testing and monitoring. If there's any changes to our business or operations, if we're adding in new departments, if we're acquiring new businesses, it's not enough to just make sure that our core is really secure. We want to make sure that we're constantly assessing the entire picture and making sure that we're accounting for that. Element 8 is incident response. A covered entity here is required to establish a written incident response plan designed to promptly respond to and recover from security incidents. And, we all hope that we won't have a security incident, but unfortunately in today's day and age, even companies with excellent technology, excellent practices have incidents. As I mentioned, sometimes they're because of your vendors. Your incident response plan has to have goals. It has to have the process for responding to the event, clear roles and responsibilities, including it needs to stipulate who has decision-making authority. Each external and internal communications and information sharing should be outlined in that plan. Identification of requirements for remediation, documentation and reporting, and there's a requirement that after the incident, you have to revisit the plan and you have to update it. You'll have best practices, you'll have an idea for what worked and what didn't work. So once again, that should be a living document. Element 9 is that you have to update the board. So this states that at least once a year, your qualified individual, we talked about that with element 1, is required to report to the board of directors or an equivalent body and give a report on the overall status of the information security program. So once again, I know I just ran through those incredibly quickly. There's a lot to unpack there. So, don't hesitate to send us your questions after this presentation. There is an exemption that applies to entities that have fewer than 5,000 customer records. We find that is very few entities, in an education institution, I know that you all are required to maintain information even beyond graduation dates, and that 5,000 is pretty easy to hit. But you don't have to comply with the risk assessment, monitoring and testing, incident response plan, and board reporting requirements if you can meet that under 5,000 threshold. And finally, with regard to enforcement, Gramm-Leach-Bliley and the safeguards rule do not currently have a private right of action. However, the FTC has explicitly stated that it intends to enforce the safeguards rule. In addition, the Department of Education has announced that it intends to enforce the safeguards rule, and that it would do that through annual compliance audits. So, the takeaway here is prepare for your audits and other types of examinations. That's where you're most likely to have to talk about these issues. And I think that takes me to the end of my slides. Reed, are you ready to go?
I'm ready to go.
Great. I'm just taking it. Oh, there we go. I just took it back. There you go. Thanks, y'all.
Fantastic. Good. So I'm going to talk about the Children's Online Privacy Protection Act for a few minutes here, also called COPPA. And the Federal Trade Commission is the federal agency that enforces COPPA. COPPA is a statute that was passed in 2000 and has been amended in 2013. It was passed explicitly at the recommendation of the Federal Trade Commission, who wanted to extend their enforcement of privacy protection for children's personally identifiable information. And the FTC has issued a policy statement on COPPA, which I recommend to anyone who's interested. And it starts off by saying the FTC is committed to ensuring that EdTech tools and their attendant benefits do not become an excuse to ignore critical privacy protections for children. And it goes on to say that concerns about data protection are particularly acute in the school context because children and parents often have to engage with EdTech tools in order to participate in school-related activities. And so the FTC is seeing this as an area where it needs to insert itself and make sure that student data is properly protected. The penalties for violating COPPA are the same as for violating other FTC statutes, and they're pretty severe. They can be up to $50,120 per violation, which could be per child. Also could include changes to business procedures. And so this gives the FTC huge discretion in enforcing because the potential liability here is huge. So what does COPPA require? Well, it prohibits the collection of personal information of children who are under 13 by websites or online services that are directed toward children. And we say here prohibits, but really it prohibits unless certain safeguards are put into place, which we will go through in some detail. It also applies if you operate a website or an online service that's directed to the general population, where you have actual knowledge that you are collecting personal information from children under 13. So for instance, you have a website that is directed again to a general population, but you ask people to put in their age as part of accessing the website or a portion of that website. Well, now you have specific information, you have actual knowledge of users, if there are any, who are under 13. And so that triggers COPPA and triggers the obligations to protect the data of people who have put in an age of under 13. Then finally, if you have actual knowledge that you're collecting personal information from users of another website or online service that's directed to children under 13, that triggers a COPPA obligation. So you have to be careful even where you're using the data of another website or online service. There are some limited exceptions. There's a chart on the FTC's website where you can collect limited information like name and contact information, really for the purpose of, you may need some limited information in order to make sure that you are complying with COPPA. Like, for instance, you get the name of a student and a name and contact information of their parents so that you can seek out consent to store the student's data. So what are the main requirements of COPPA? You need to provide notification about what information is being collected, how it's being used, and what your disclosure practices are. You need to obtain parental consent prior to collection, use, and/or disclosure. That's brings up some interesting issues in the context of schools where parental consent might be tricky to obtain. We'll come back to that. You need to provide reasonable means for a parent to decline to provide the data or to review the information that's being collected. You can only collect information that's reasonably necessary to participate in the online activity. And then you have to implement and maintain reasonable procedures to protect the security of the information. And then once the information is collected, then it has to be deleted once it's no longer reasonably necessary to fulfill the purpose for which the information was collected. And really, the idea here is if you need data in order to operate your online service, that is okay. Such, if you have an EdTech tool that requires certain data of a student, that's okay, again, as long as you obtain parental consent and you follow these processes. But if you take that data and you sell it to a third-party advertiser, that's really the focus of what COPPA is looking to prevent. So we have a number of recent COPPA enforcement actions by the FTC, and these were all violations of both the COPPA rule and of Section 5 of the FTC Act. Section 5 of the FTC Act prohibits false or misleading practices, including advertising and other marketing. So there are a couple high publicity actions outside of the EdTech space. They've been against Epic Games, Amazon, Microsoft. In particular, the Epic Games, the FTC obtained a fine against Epic Games of $520 million. Half of it was in restitution to users, and there were some allegations that went beyond COPPA, but a huge fine there. Microsoft and Amazon were in the $20 million range, but you can see that the FTC is obtaining some huge fines here. Within the EdTech space, the FTC had a recent action against EdTech provider Edmodo, and the fine there was $6 million, though it was reduced for an inability to pay. But Edmodo is an online virtual classroom tool. It really boomed during the pandemic. Teachers can host discussions on it. They can share materials, give quizzes, conduct other types of activity that is usually done in the classroom. And Edmodo collected a lot of information about students, including their geolocation data, a profile picture in some instances, cookies, IP addresses, and so forth. And they had a free version of the platform, but the way that they monetized it was to use the data of children for advertising purposes and also to develop models and algorithms. And in addition to the improper use of the data, Edmodo also did not provide parents with direct notice or obtain their parental consent. Essentially, Edmodo said to the schools, it is your responsibility to obtain parental consent to use our services. And the FTC said, no, it's really on Edmodo, on the EdTech company, to make sure that the parental consent is in place. And then I think it's worth mentioning here that there also has been a recent FTC enforcement action outside of the COPPA context against Chegg, which is a marketer of online learning aids, of homework helping tools. And Chegg is targeted more toward high school and college students. So it doesn't fall under COPPA because we're talking about children or young adults who are over the age of 13 or older. But there, Chegg knew that it had some data security problems, wasn't active in fixing them, and so the FTC stepped in and brought an enforcement action against Chegg. So what are our takeaways about COPPA for EdTech companies? Well, first, it's important to be familiar with the policy statement and the guidance on the FTC's website. There's quite a bit there. It's very detailed and can always help folks parse through it, but it's good to start there. Second, you should have a plan for collecting parental consent, for using the data that you're receiving, and also for safeguarding it. And probably add to that deleting it as well. Very important. Third, don't put the onus of COPPA compliance on schools. I talked about the Edmodo example. There is a very limited exception that the FTC walks through in its guidance, where you can rely on authorization that schools have already received from parents if you agree to only use the data for educational purposes and you notify the school of collection, use, and disclosure practices. And then you have to delete the personal information in a reasonable time frame. 1 year has been found as reasonable, as I've discussed. And then finally, even if you're collecting personal data from students who are ages 13 and older, where it would not fall under COPPA, you still need to be careful about safeguarding the data so that you're not running afoul of the FTC's other statutes and rules. So with that, I'm going to turn it over to Farnaz, and we're going to switch seats here as I have intruded on her office. So thank you all very much.
We are going to briefly address the future of online program managers and whether they may be third-party servicers. As you all are probably aware, the Department of Education issued guidance on February 15th regarding third-party servicers, and for the first time implied that online program managers might be third-party servicers, which is very odd because third-party servicers are technically defined to be servicers that perform services related to federal student loans. And online program managers sometimes, but not usually, they don't usually even touch federal student loans. And the department kept delaying the effective date of this particular guidance, and 2U and its South African subsidiary sued. And what's interesting here is that the guidance stated that third-party servicers could not be owned or managed by foreign entities, and that was also problematic. And when 2U sued, before the Federal Department of Education had to respond, the Undersecretary issued a blog post on April 11th, basically staying the effective date of the guidance indefinitely, stating that the department received over 1,000 comments and would be issuing revised guidance. And then the department clarified on May 16th that the department would issue final revised guidance regarding what constitutes a third-party servicer, and that institutions that receive federal student aid would have at least 6 months to comply with the guidance after it's issued. And in this announcement, the department, both in the blog post on April 11th and also the Dear Colleague letter on May 16th, clarified that they are going to rescind the prior guidance that prohibits contracts between colleges and foreign-owned or operated servicers, and that they may address this topic through negotiated rulemaking. They've issued notices for negotiated rulemaking on this topic, but they have not technically addressed whether a foreign entity may own or control a third-party servicer or, frankly, an online program management service. So where are we now? Here's what we know. The department did clarify that certain activities do not qualify a company as a third-party servicer. So contracts relating to study abroad programs don't count in the third-party servicer category. Recruitment of foreign students not eligible for Title IV aid, clinical or external or externship opportunities where the institution closely monitors the students who are part of those programs, course sharing consortia and arrangements with Title IV eligible institutions to share employees or teach courses or process financial aid, that's permissible. Dual or concurrent enrollment programs with respect to high schools and elementary and secondary educations, those also are exempt from being third-party servicers because they don't actually relate to Title IV federal student aid at all. And also local police departments that help gather crime statistics for Clery Act reporting services, that's still permissible as long as the local police department is not filing a report on behalf of the institution. The local police department would not be considered a third-party servicer. So what we know is that the department's original guidance was extremely broad and saying that certain entities would be third-party servicers, and the consequences of being a third-party servicer with the GLBA and the requirements that Ashley went over. You would be jointly and severally liable with the college or the university for any acts or omissions of the college or university with respect to Title IV. You would be liable for anything else that the Title IV, the Higher Education Act, requires, and there are a lot of requirements there with respect to regulations. You'd have to comply with the Family Educational Rights and Privacy Act, also known as FERPA, and you would have to report fraud or criminal activity to the Office of Inspector General. So there's a lot of different things with respect to third-party servicers, and the thing to note is that 2U Inc.'s lawsuit has not gone away. So the federal district court in DC stayed the lawsuit, but stated that once the Federal Department of Education issues its final guidance on third-party servicers, then there is an expedited briefing schedule for the court to consider whether that guidance is lawful, whether the department actually has the authority to issue that guidance under both Title IV, the Higher Education Act, as well as Administrative Procedure Act, because as you know, with respect to regulations under Title IV, especially regulations that define what a third-party servicer is, the department is required to go through negotiated rulemaking. So it would be odd if the department issued guidance with regulations, guidance, but not regulations, and had specific requirements and guidance that were not in the statute and that were not in regulations. And the statute very much focuses on the definition of a third-party servicer as being related to an entity that processes federal student aid or federal student loans for the particular college or university. So while colleges and universities, as well as EdTech companies, are waiting for the Department of Education to finalize its guidance, I think you know what the worst case scenario is. And the worst case scenario is the guidance that the department issued on February 15th. So while there's this lull and we're in this waiting period, I've had some EdTech companies choose to revise those contractual agreements to clarify the services that they are providing for institutions of higher education and to clarify where they don't fall within the guidance on February 15th. Of course, the department has yet to issue its final guidance, but you can, I think, safely assume that if you don't qualify as a third-party servicer, even under the very broad guidance issued on February 15th, then you very likely will not qualify as a third-party servicer in any final guidance issued. That will likely be much more narrow. And with that, To discuss what the department has the authority to do and not to do is my colleague and partner, Jonathan Ellis.
Thanks, Farnaz, and thanks to all of you for sticking with us. I know we've been going for quite some time. Wanted to finish with just a few words, looping back to the beginning of this presentation about the use of AI in education, and in particular what the U.S. Department of Education has said or may be doing in this space going forward. So the bottom line up front is that the Department of Education has not yet issued any AI-specific regulations and has not issued any real significant binding guidance or concrete guidance on how existing regulations are likely to apply to the use and development of AI in education. That doesn't mean it hasn't said anything. It issued in May of this year a 64-page guidance document that was compiled by the Office of Educational Technology, addressing sort of more in aspirational terms and future-looking terms about how AI might be developed and how regulations and guidance might be developed around its use in the classroom to realize its opportunities and mitigate its risks. That document is called the Artificial Intelligence and the Future of Teaching and Learning. If you are interested in AI and how it's going to be and is being deployed in education, I would encourage you to take a look at it. We're going to spend a couple minutes this afternoon on it, but we're really going to fly through. It's a thoughtful document with some interesting insights and recommendations. It was built based on 4 listening sessions that the department held in June and August of last year with educators, researchers, policymakers, and technology developers. And it's informed by the White House's recently issued blueprint for an AI Bill of Rights. The document starts by addressing and echoing some of the things we talked about this morning, why AI is important and why it needs to be addressed and addressed now as it's used in education. And the first is that AI can enable better educational outcomes and opportunities at lower costs. It talks about improving the adaptivity of learning resources for students, about aiding teachers through automated assistance and enabling them to more efficiently support their students in ways that you can well imagine based on Justin's presentation, your own experience with AI. But at the same time, it recognizes that AI presents risks to privacy and security, to equity, and to educational quality. In particular, it flags that the fact that AI can subject students to greater surveillance by both teachers and third parties. It can introduce discrimination, as we've noted, through algorithmic bias based on how the models are built. And it can present information that appears trustworthy on its face, but is actually inaccurate. And finally, because of AI's automation and its efficiency, it can present those strengths, those opportunities, and those risks at a very broad scale. And so the document is based on 4 foundational concerns drawn from these listening sessions and the blueprint from the White House. The first is the center people, it says. It wants to, so teachers and learners need to retain their agency as they choose the way they learn and the way they teach. The second foundation is the desire to advance equity, avoiding those algorithmic bias and unwanted and unintended discrimination through the models of AI. The third is to ensure the safety, ethics, and effectiveness of the AI. And the fourth is to promote transparency. It talks about wanting decision makers need to know how these models are actually built, what they're doing, and need to understand their limitations, their problems, and their risks. Based on those foundations, the Department of Education's guidance then goes through those insights and lands on 7 non-binding recommendations about the development and deployment of AI. These recommendations are not all for folks on this call necessarily. Some addressed all the constituents in the education space who are looking at this issue. Some are directed specifically to policymakers or decision makers at educational institutions. Some are directed at technology developers. But the first is really echoing back to that first foundation of the guidance, and that is to emphasize humans in the loop. And I like this metaphor that the guidance uses. It says they want to make the use of AI more like an electric bike than a robot vacuum. They want to see that humans should be still fully aware and fully control, while their burdens are lessened and their effort is multiplied, like an electric bike, not out of control, not disconnected as the robot vacuum in my house goes about its business in ways that I can't understand. Second, it says, recommends to, this is the policymakers and decision makers, to align AI models to a shared vision. It warns against sort of adopting AI for AI's sake or being wowed by the sort of futuristic experience of it all, and to make sure that policymakers and decision makers are naming the educational goals and then measuring the degree to which various AI tools and models fit those goals and are useful to those ends. Third, it recommends to technology developers, the people making these tools, to design using modern learning principles. It mentions that existing technologies are often focused on identifying and then fixing a students' weaknesses. And it recommends and encourages those future tools to look to harness AI in order to recognize and build upon learners' strengths. Fourth, it talks about prioritizing trust, strengthening trust. It notes that AI can't achieve the goals that and its promise unless people use those tools, and people aren't going to use those tools effectively unless they trust what the output and the way they're being deployed. And so it really directs this recommendation to associations and societies, teacher unions, and others who are in the education space who can help build that trust among educators and learners. Fifth, and this group should like this recommendation, it encourages policymakers and people in the industry to inform and involve educators at every step in the process of designing AI, of developing the tools, of testing those tools and improving them and adopting them. It really points out that the way these things are going to be most effective is to involve those educators who are on the front lines using these tools to make sure that they serve the needs of education. Sixth, it recommends to technology developers to focus their research and development on addressing context and enhancing trust and safety. It encourages these developers not to focus just on the median learner, but to make these tools more sensitive to the differences in different learning abilities. This is one of the benefits of AI in improving adaptivity of our resources. It encourages developers to look at learning abilities, different learning abilities and disabilities, and to consider different environments, like those tools that might be used in the classroom or the home, and to consider the different cultural backgrounds that people bring to the table using these tools, and to make sure that throughout those contexts, the tools remain effective, safe, and trustworthy. And the last, which will fold us into the next part of this discussion, is that it encourages policymakers, federal and state, including the department itself, to develop education-specific guidelines and guardrails around the deployment, design, and use of AI in education. It flags, in particular, the Family Educational Rights and Privacy Act, FERPA, which we've already discussed, and COPPA, which we've already discussed, as well as CIPA and other statutory authorities. And it encourages policymakers to go back and review and consider the existing regulations and laws and how they might apply to this new context. Finally, the guidance ends with talking about what the department's next steps would be, and it puts them in three categories. The first is regulation. The department promises that it will consider specific policies and regulations to realize the opportunities of AI in education. Second, the department promises to develop additional resources for those who are in the education space using AI and who want to deploy those to understand how they are best deployed. And third, it promises to revise and update the National Education Technology Plan to guide constituents towards safe, equitable, and effective AI in education. So that leads us to a discussion, a brief one, about what's likely to be coming. As I say, there are AI-specific regulations from the department today, but I do think it's fair to expect them to be coming. In the document, it flags specifically, as I noted, more reviewing and giving further consideration to existing regulations under FERPA. It goes on to say that the issues there are not that are presented by AI are not only in data privacy and security, but they extend to things like bias and transparency and accountability. And it flags that while general frameworks that are going to be developed and are being developed for responsible AI in other sectors like health and safety and consumer products are likely to be informative, but are not likely to be sufficient for education-specific needs. So I think it's fair to expect regulations and guidance to be coming from the department. What authority might it rely on for those regulations? Well, the guidance and other previous documents have identified at least 3 different statutory authorities that the department could act under. The first, we've already mentioned a couple times, is FERPA, which limits the authority of schools to share student education records without parental consent or student consent. The second is the PPRA, the Protection of Pupil Rights Amendments, which limits the authority of schools to collect and disclose certain personal information, student information, or sensitive information without sometimes notice and opt-out, sometimes prior consent. And the third is the Individuals with Disability Act, the IDEA, which of course assures children with disabilities have available to them a free, appropriate public education designed to meet their needs. Now, because there's not regulation on the books and not even a proposed regulation, I'm not going to weigh in as to exactly how that might apply and what those regulations look like. But I want to take a minute to address whether this regulation might be enough, and really just a minute because we're running short on time. Just last month, the Supreme Court, of course, passed on whether the department's statutory authority was enough to justify another policy of theirs they adopted recently, which was the Student Loan Forgiveness Program. The court, as you probably know, held that the HEROES Act didn't provide the department with sufficient authority for that program, and it did it for 2 reasons. The first was based on a careful analysis of the specific language of the HEROES Act and its authority for the Secretary to waive or modify statutory provisions in Title IV. The second was under the major questions doctrine, a doctrine that the court has deployed, the Supreme Court has deployed recently in several cases, in which it said that existing language wasn't sufficiently clear to authorize a program of such vast and economic and political significance as the Student Loan Forgiveness Program. The court noted that the department had never previously claimed powers of that magnitude, that the program affected a significant portion of the economy, and that it reflected a policy that Congress had tried but failed to enact. So how is that relevant to any future regulations of AI? Well, I can see a couple different ways. First is that I think we've already talked about the widespread development and adoption of AI presents unanticipated challenges that the existing laws might not be well designed to address. The second is that considerations of need, good faith considerations of need, as well as sometimes political expediency, can lead federal agencies to stretch existing authorities in order to address challenges that they see. And when they do that, courts are increasingly skeptical of actions, depending on the extent to which new regulations depart from the agency's previous exercise of their authority, exert control over political and societal, of questions of political, societal, and economic significance, and enact policy that Congress has previously considered but failed to adopt. Whether that comes into play in any future regulations, I think we'll have to just stay tuned to see, but it's something to think about as the department begins to act here. With that, I think we've reached the bottom of the hour and the bottom of our presentation. I don't see any previous questions, but maybe I'll turn it back over to Farnaz to close us out.
Thank you, Jonathan, and thank you for joining us. Please send Heather Fuentes an email if you would like CLE credit for this presentation and for this webinar. And please feel free to contact me or any of my colleagues if you have questions. Thank you for joining us. Bye-bye.